Thank you. Good morning, ladies and gentlemen. I'm Robert W. Matanke, president of the Decalogue Foundation and a past president of the Decalogue Society of Lawyers, the Jewish Bar Association founded in Chicago in 1934. Welcome to our presentation on CRC Divorce Mediation. Today's program is presented in memory of our past president, Jerry Bender, who served as a judge in the Domestic Relations Division of the Circuit Court of Cook County. It's being co-sponsored with the Chicago Rabbinical Council, the American Academy of Matrimonial Lawyers, and Lincolnwood Jewish Congregation AG Beth Israel, of which he was a proud member. We encourage you to support the Decalogue Foundation, a 501c3 charity, so that we can continue to provide legal and educational programming and scholarships to support the law and Jewish law students. I will introduce each of our panelists, and following all of their presentations, Judge Mitchell Goldberg, who serves as Vice President of the Decalogue Foundation, will moderate a question and answer session. During the presentations, you can enter questions in the chat box so that they can be posted to our panelists during the question and answer session. For those attorneys who have registered to receive mandatory continuing legal education credits, please make sure that you complete the evaluation form at the end of this program. Certificates of attendance for CLE credit will be emailed within the next few weeks, and there will be a posting on the website of the ARDC by the end of this coming weekend. And now it is my distinct privilege to introduce this morning's panelists and our moderator. Our first panelist is Rabbi Yonah Rees, who is the Av Beis Din of the Chicago Rabbinical Council and a Rosh Yeshiva of the Rabbi Isaac Elchanan Theological Seminary at Yeshiva University, commonly known as REITS, where he serves as the Rabbi L. Katz Chair in Professional Rabbinics. He is also the Sgan Av Bet Din of the Beth Din of America in New York. He previously served as the Max and Marion Grill Dean of REITS. Rabbi Rees received Yora Yora and Yadin Yadin Smicha ordination from REITS and is also a graduate of Yale Law School, where he served as a senior editor of the Yale Law Review. He has published many articles on Jewish law and on American law, including in Techumin, the Wall Street Journal, and the New York Law Journal. Rabbi Rees is the author of Kanfei Yonah, a Hebrew language compendium of essays and responsa about contemporary issues in Jewish law and Talmudic topics. The Sefer, Kanfei Yonah, that book that he published, received approbations from leading rabbinic authorities throughout the world, including the past two chief rabbis of Israel. Rabbi Rees will be interviewed by Judge Mitchell Goldberg, an associate judge of the Circuit Court of Cook County, where he serves in the Domestic Relations Division and is currently assigned to the District 5 Courthouse in Bridgeview. Prior to his elevation to the bench in October 21, Judge Goldberg was a longtime partner at the Chicago law firm of Lawrence Kamen, LLC, where he practiced in the firm's regulatory and litigation groups. He also was on the adjunct faculty of IIT Chicago Kent's College of Law and Northwestern School of Continuing Studies. Judge Goldberg has served as a leader in several bar associations. He is also a past president of the Decalogue Society of Lawyers, where he currently serves as co-chair of the Standing Committee Against Anti-Semitism and Hate. He currently serves as president of the Chicago Lincoln American Inn of Court and serves on the board of the North Suburban Bar Association. Among his other volunteer roles, he is currently chairman of DePaul University's College of LAS Dean's Advisory Board. Judge Goldberg received his JD and BA degrees from DePaul University. And now please join me in welcoming Rabbi Rees and Judge Goldberg to the program.
Thank you very much. As a point of personal privilege, I also want to point out that Judge Gerald Bender, in addition to being a past Decalogue president and domestic relations judge, was a mentor and friend to many young attorneys, including myself. And I'm so very honored to be here with you all today, just as I'm also honored for the privilege to serve the people of Cook County in the same division as Judge Bender, which is so related to today's lecture. It's my privilege to be able to be on a panel with Rabbi Rees, and I'm hoping that you're able to give us some deeper background and understanding regarding the role of the Beis Din, as well as some of the Jewish legal issues and unique Jewish issues that occur during divorce matters. Could you describe the Jewish divorce process in a Beis Din? And for benefit of the members of the audience, a Beis Din is a rabbinical court. And also, can you explain how similar or different it is from the regular civil law divorce process?
Well, thank you very much, Judge Goldberg. It's really a privilege for me to be here today And I want to welcome all of the attendees and thank the organizers of the program, Robert Matenki, and the other members of the Decalogue Society as well. It's really a very interesting process when we deal with divorces at the Bet-In. I'm hearing a little bit of an echo. I don't know if other people are hearing an echo too. Okay, now it went away. So the Bethlehem process is really similar in many ways to the civil divorce process, but unique in the sense that it furthers the Jewish law objectives of what is required whenever a Jewish couple goes through divorce. Of course, Judaism recognizes the possibility of divorce. It does not encourage it per se. It views it as a tragedy whenever a marriage doesn't work out. Every marriage is viewed as sacred, and we certainly try our best to save marriages and to maintain and to support marriages as much as possible. But Judaism always recognized, already from biblical times, that sometimes it's better for a couple to get divorced and that the marriage doesn't work out. And we don't believe entrapping anybody in a marriage which is not functional anymore. In terms of the process of divorce, the most uniquely Jewish feature of the Jewish divorce process, in terms of a component that doesn't exist in the civil divorce process, is the requirement for a get, a Jewish bill of divorce that needs to be authorized by the husband and given to the wife. It has to be done under very specific laws and rules and regulations, including that it should be supervised by knowledgeable rabbis. That's why we have a bet-in, a rabbinical court involved. The names of the parties have to be written very specifically. The get document has to be written with special Hebrew calligraphy, has to be signed by people who are considered to be kosher witnesses in the Jewish tradition. The husband has to authorize it of his own free will. And according to rabbinic law, a husband cannot divorce his wife against her will either. And therefore, we require the full consent of both parties, which also is a tricky matter when you have sometimes an acrimonious or contentious divorce, to engage in proper persuasion of the husband and the wife to cooperate fully in the Jewish divorce so that neither of them are going to trap them in a situation where they might be civilly divorced, but they wouldn't be considered divorced according to Jewish tradition. If that would be the case, for example, a get would not be given and a woman would remarry, it would be considered an adulterous relationship. Any children born of that union would be considered to be illegitimate. And even for a husband to marry another wife, if he hasn't given his first wife a get, while in biblical times, a man can be married to more than one wife, there was a special enactment that was made by Rabbeinu Gershom, who was a great rabbinic leader 1,000 years ago, that established that a man is also not allowed to get remarried unless he has given his first wife a get. So therefore, this is an essential process for both parties and requires the careful supervision of a rabbinical court. Now, the other components of divorce, which are also supervised by the rabbinical court process, especially when the parties have submitted to our jurisdiction, which is really the requirement under Jewish law. Really, cases are not supposed to be litigated between two Jews in civil court, whether it's a commercial case, whether it's a matrimonial case, whether it's a communal dispute. They're supposed to go to the rabbinical courts. So therefore, parties come to us to litigate and to mediate and arbitrate other aspects of the divorce process as well. That includes the spousal support. In Jewish law, spousal support is generally addressed through the ketubah. People sometimes are not aware of what the ketubah document that's signed at the time of marriage is all about. The main purpose of the ketubah is to provide support for the wife in the event that the couple gets divorced or the husband dies, unfortunately, that she should receive an amount that will be able to take care of her. That really is the fundamental purpose of the ketubah. Nowadays, when parties often have the expectation that the way in which they will establish maintenance amounts will be more in accordance with the customs of the secular court system, that's also okay. but the Bet Din has to determine in each case how this ketubah or spousal support obligation will be properly paid out. And the next area of adjudication is with respect to the division of assets. Jewish law had originally anticipated that the husband's going to be the main breadwinner and that he will provide support and maintenance to his wife during the marriage, in return for which he would receive her earnings, unless, of course, she makes the decision on her own that she's fine taking care of herself. She doesn't need the husband to give her food and support, and she'll keep her own earnings. And that certainly is the prerogative of a wife. And nowadays, that's often the default to supposition when you have both husbands and wives who are out there in the workplace. And in many cases, the assets will be divided 50-50 because Jewish law does recognize the idea of marital property, particularly when you have major assets like homes that are acquired in the name of both parties and bank accounts that are joint bank accounts in the name of both parties. Although if the parties do have a regime or understanding, especially in second marriages, that there will be separate property, so Jewish law respects that as well. Third area, when there are children, is child support. Beis Din does have a jurisdiction, even under secular law, to adjudicate child support matters, as long as it's mindful to be cognizant of and respectful of the child support standards guidelines. But of course, under Jewish law, there are special circumstances that need to be taken into account as well, such as the need to pay for tuition in yeshivas, in Jewish schools, and other expectations of sending to certain types of camps and other types of religious extracurricular activities that would be appropriate for children who are being brought up in the observant Jewish community. And secular law would also recognize the importance of adjusting the child support formulas to deal with those realities and those needs of the children. And then finally, there's the question of child custody. Child custody is handled according to Jewish law based on essentially the same guideline as is followed by the civil courts, namely the best interest of the children standard. However, Jewish law takes into account not only considerations of what's best for the physical and psychological welfare and the well-being of the children in terms of custodial and parenting arrangements, but also other types of considerations, such as what's going to be the best home and the best arrangement that will further the Jewish education of the children, assuming that the idea was to bring them up within the observant Jewish community in accordance with the traditions of Judaism. And secondly, also to take into account what's going to be the most positive environment for them to nurture Jewish values and Jewish ethics and Jewish notions of modesty and demeanor and conduct as well. So a Bet Din will take all of those factors into consideration in terms of working with the parties to fashion an appropriate custodial arrangement. The other unique features of going to a Bet Din when it comes to the divorce process, particularly beyond the get, when it comes to dealing with all of these other factors and all of these other types of decision making, is also the fact that the Bet Din has more of a cultural familiarity with the parties and their circumstances and situations, so that the Bet Din is able to understand more the needs of the parties, what the parties require in terms of furthering their Jewish identity and upbringing of their children and the maintenance of the family in general, and to understand the cultural sensibilities and sensitivities of both husband and wife in that particular context. And particularly when it comes to understanding the significance of taking care of the get, the Jewish divorce. Another advantage of the going through the Bet Din process is that economically it tends to be much more feasible for the parties. We're not nearly as expensive or as extensive a process as what the parties will go through in terms of the court system. and we're able to keep things on an even keel so that it doesn't end up being overly contentious, more than it needs to be anyway. And there's more of a sense of informality when dealing with a community organization, a greater sense of access, 24 hour around the clock availability to deal with emergency situations. Sometimes we're a little bit too available, I feel. Mrs. Lipman can discuss that in terms of the role that she plays when it comes to the divorce mediation performed by the Betin. But all of this has to be done, and we're very careful about doing this at the Chicago Rabbinical Council with a sense of professionalism and an emphasis upon a due process with rules and regulations that are published and that need to be followed very carefully.
Thank you so very much, Rabbi. When is a get supposed to be given, and can courts be used to require a get?
So there really are two requirements for when it's appropriate for a get to be given. The first is when it's clear that the marriage is irretrievably broken down and that it can't possibly be saved. And the second is that the parties have to be living separately. They can't be underneath the same roof. They have to have separate residences under Jewish law in order for the get to be given. But once those two factors are in place, it is a misconception that people have that you have to wait until the conclusion of the civil divorce or the resolution of all of the other divorce issues before a get can be given. Really, at that point in time, it's appropriate to get the get out of the way. And that's so that neither party will use the get as a weapon or as a leverage or as a bargaining chip, but of course that's an improper usage of the get. The idea of Jewish law is that once it's clear that the marriage is over, then it's supposed to be matter of fact. That, of course, at that point in time, the get is given in order to memorialize the ending of the marriage and to enable the parties to be able to move on with their lives. It was a great rabbinic figure named Rabbi Yosef Eliyahu Henkin, who wrote an article in one of the major Torah journals in the mid-20th century, in which he said that he felt that it was a big mistake. The parties sometimes wait until the end of the process because then, if they're not so observant, they might forget about it. And even if there's an understanding of the importance of the get, if one party is displeased, particularly this happens more in cases with a husband, if the one party is displeased with the conclusion and the outcome of the divorce decision, then they might decide that out of spite or to suddenly use it as a bargaining chip, they're going to withhold the get unless the other party agrees to financial concessions or changes in the parenting arrangements that might not be in the best interest of the children. And he said that's a very dangerous thing, so that should be avoided at all costs. Because the courts recognize that this is something which really can restrain a person's freedom from being able to remarry, courts have gotten a little bit more involved. It's tricky. Because of the First Amendment to the Constitution, of staying away from any kind of establishment of religion or restricting parties of free exercise, either to practice religion or not practice religion, as the case may be. Courts have worked together with rabbinical courts based on more of a contractual model. So you have the Goldman case in Illinois, where the parties had signed the ketubah, and one of the clauses of the ketubah was that they would live their married life according to the laws of Moses in Israel, based on rabbinic testimony that was rendered at the court, including by the previous Abbot and the previous chief rabbinical judge of the Chicago Rabbinical Council, Rabbi Gedalia Dov Schwartz. The court concluded that this line in the ketubah, the Jewish marriage contract that was signed by both parties, required that at the time of the dissolution of the marriage, the husband was required to comply with the giving of a get. Not all jurisdictions have followed that decision in the Goldman case, especially since it's not spelled out explicitly in the ketubah to actually give the get. And other jurisdictions, including in New Jersey in the Aflalo case, say that mandating a religious act really does seem to be problematic from a constitutional perspective. So really, the best thing that the parties can do from a contractual view is to sign a prenuptial agreement at the time in which they get married, which simply states that they are committed, that they will submit to the Betin in our case, the Betin of Chicago Rabbinical Council, in case there is any dispute regarding a get, and they will comply with the directives of the Betin, which can include that they will comply with the giving of a get, and can also include that the Betin is authorized to impose financial penalties, or at least requirements of financial payments that, from a Jewish law perspective, wouldn't even be viewed as punitive. That simply because the husband and wife are still living together, the husband has an obligation to provide support under Jewish law for as long as they're still married according to Jewish law, which means until the get is given, and that provides a financial incentive, one that would be more capable of enforcement by the civil courts across all jurisdictions, as an incentive for the husband to give his wife a get.
I can
Thank you.
interrupt one question. The procedure you have, standard procedure, is to try and have the get delivered as soon as possible. Does that modify in the event that the husband is a Kohen?
Again, you bring up the question, if a husband is a Kohen, he would not be allowed to remarry his wife upon divorce, because a husband is not allowed to marry a divorcee, including the woman he was once married to, whom he subsequently divorces. It doesn't change, because one of the prerequisites of deciding that it's time to give a get is when the marriage is irretrievably broken down. So in such a case, we're not so concerned about the fact that this Kohen won't be able to remarry his wife, because the marriage is simply not workable. And therefore, there is no expectation that it would ever be appropriate for the two of them to be married again. But it is a very good question.
Thank you very much, and thank you, Bobby.
Thank you.
For the benefit of the audience, the in remarriage of Goldman case is an appellate court of Illinois case from 1990. It's in the materials. The case citation is 196 Ill App 3rd, 785, and it is still good law. With respect to what you just talked about regarding the importance of certain contractual interpretations, how does the Beis Din receive jurisdiction to decide a divorce case, and are its decisions binding?
Beis Din typically receives jurisdiction based on the parties signing an arbitration agreement. When they sign the prenuptial agreement functions as an arbitration agreement, where the parties willingly say that they select the Beit Din as their judicial forum to adjudicate any disputes, and then any decision of the Beit Din will be binding. The Beit Din then has a responsibility to follow all the requirements of arbitration procedural law that are set out in the Illinois statutes. Every single state has arbitration laws of procedure, which require, for example, that the parties be given time and notice of whenever any proceeding will take place, that the parties have the opportunity to provide whatever evidence and bring whatever witnesses they deem appropriate in order to present their case, that the Beit Din or other arbitration tribunal, as the case may be, not listen to the testimony of one party in an ex parte basis outside of the presence of the other party, that, of course, the Beit Din not engage in corruption or fraud or duress. But assuming that all of those procedural requirements and safeguards are followed, then the decision of the Beit Din, which would be rendered in writing, would be enforceable as any other decision of any court of competent jurisdiction. That's how arbitration law works. The same way that it would work if the parties submitted to arbitration in front of the American Arbitration Association. It works the same way when the parties agree that they're going to submit in front of a rabbinical court. It could be a standalone arbitration agreement, or it could be incorporated in the parties' prenuptial agreement, which is what we recommend, because at the time of marriage, that's when they're more likely to be lovey-dovey, to be on the same page, to agree what the arbitration forum and which Beit Din they both are comfortable going to, so it ensures the fairness of the process and the equal bargaining power of the parties. The decisions of the Beit Din are generally binding. We've had our decisions enforced in court once it's shown that we complied with all of the arbitration procedures. And in fact, there's a presumption that an arbitration decision is going to be enforced by the courts. The one area which is a little tricky is in terms of child custody, based on the parens patriae principle, that the courts view themselves as the ultimate guardians for children. So an arbitration agreement to submit for an arbitration decision-making process by a Beit Din when it comes to child custody would not necessarily be enforced by the courts. However, what we do at the Beit Din to ensure enforceability is to engage in collaborative arbitration, which means that we work with the parties and the lawyers together, where everyone is comfortable going to the Beit Din as their dispute resolution forum. First, we try to resolve the case through mediation, which is, of course, a completely voluntary process that the parties can withdraw from at any time. But then if the mediation doesn't work out, everyone agrees that we'll go through arbitration. We will use child therapists and child experts that will advise the Beit Din that the lawyers are comfortable with. And there's an agreement and understanding that when we've reached the end of the process, we've rendered our recommendation or determination, the lawyers will then incorporate that into a marital settlement agreement, a parenting allocation agreement, which will be signed at that point by the parties. Once it's signed by the parties in collaboration with their attorneys, then it becomes an enforceable agreement. Then the court, unless there's some sort of arbitrary and capricious agreement that would shock the conscience, so to speak, the courts will generally respect the parents' own decision of how they're going to allocate parenting time and parental responsibilities. So that way it ends up being an enforceable determination from the standpoint of from the standpoint of the parties and from and through the Beit Din process.
Thank you. As an aside, one of the ways that I actually had the opportunity to meet and interact with Rabbi Reese before I became a judge was as a practitioner. Frequently, the CRC basin was used as the arbitration forum in business disputes for clients of my own. And my clients and other attorneys that were involved in those disputes were kind of surprised in a very pleasant way of how sophisticated the basin was in handling really complex business disputes. And it became a preferred forum for many of my colleagues.
Some of us have even gone to pretty good law schools.
Very much so, indeed. With respect to confirmation of arbitration awards, just like any other arbitration forum, the Uniform Illinois Arbitration Act as well as the Federal Arbitration Act have confirmation of award provisions, and you can go to a court of general jurisdiction or even a federal court for things that touch on federal law for purposes of confirming the awards and rendering them into judgments which are enforceable through enforcement proceedings. Can you explain the role, Rabbi, and the purpose of the Beit Din's prenuptial agreement? It's been mentioned a few times.
The prenuptial agreement essentially accomplishes two things. Number one, it provides for binding arbitration where there is a dispute, for example, regarding the giving of a get, which would not otherwise be something that a court could easily handle. Certainly in many jurisdictions, the Goldman case is not considered to be binding law. And even in Illinois, you can argue that the circumstances of that case were specific to that case, and rabbinic testimony as to how to interpret the laws of Moses in Israel in the context of that divorce. It ensures that the Beit Din will be able to have the jurisdiction to issue decisions regarding the get so that a woman won't be an aguna. She won't be trapped in a non-functional marriage because the husband refuses to give her a get, for example. And number two, it provides a monetary incentive for a get to be given because it says that the husband undertakes that he will pay a certain quantifiable amount of money as a support for as long as the couple is married according to Jewish law. Since it's a support obligation, it's not considered to be punitive under Jewish law. If it would be punitive, then it could result in a coerced get situation. So, for example, if a party went to a court without a prenuptial agreement and simply got the court to compel the husband to give a get on the penalty that he would be otherwise held in contempt and thrown into jail, and he gives a get on that basis, so it might not be considered a valid get under Jewish law. But if he gives the get because he signed contractually a prenuptial agreement that he's going to support his wife no matter what, even if they're separated, to the tune of a certain amount every single day, which is calibrated to be the amount of the cost of living of the parties, which is about $55,000 a year, probably more than that, but it's certainly not a punitive amount. So then if he gives a get to avoid that obligation, it will not be considered to be a coerced get. So the prenuptial agreement helps to put that obligation in place as well.
Thank you so much. And my last question for purposes of this interview is, if the Beit Din does not have legal jurisdiction, can it still play a role in facilitating the Jewish divorce process?
It certainly can. First of all, the Beit Din can engage in the process through moral persuasion and its religious authority. the bet din can still issue a summons to a party to show up in front of the bet din in order to satisfy their Jewish law obligation. And if they don't satisfy the Jewish law obligation, then the bet din can issue a contempt order, which would be spread around the community. So therefore, a party has an incentive to remain in good standing within the community to cooperate and comply with the bet din process and the organizations, such as the Organization for the Resolution of Agunot, ORA, which will engage in proper pressure that's legally permissible and halakhically permissible from the perspective of Jewish law, in order to remind a recalcitrant spouse to comply with their Jewish law obligations, including public demonstrations and things of that variety, if necessary. Secondly, Bet-Din serves as a consultation center with parties who just want to understand what Jewish law requires, or what are the Jewish law services that we provide. They can turn to us and we can help them, either whether through mediation, whether through simply engaging in part of the Jewish divorce process if they are looking to resolve their other issues elsewhere, but they just want to come to us for a get. So we're a resource center that we can help perform the get and do things according to Jewish law. We can help provide proper forms. Parties need help with contractual provisions regarding giving the get, complying with Jewish law. We can help to provide them with those forms. We can provide educational resources as well. And certainly the fact that we are present and that we do exist for purposes of providing mediation and arbitration services is just something that's a good resource for the community to know about. But even when there isn't a binding arbitration agreement, we certainly are able to assist and intervene in terms of resolving difficult divorce situations, and particularly bringing about the proper giving of a get in a timely fashion.
Thank you so very much, Rabbi. And speaking of resources, thank you for being such a great resource for the Chicago Jewish community, as well as for your time today. And with that, I'm going to pass the baton back over to Bobby Matenki to introduce our next esteemed speaker, Candace Myers.
Thank you, Mitch. Thank you, Rabbi Reese, for a most informative presentation. Our next panelist is, as you just, pardon me, I thought Alana was going first, Mitch. No?
Okay.
Okay. Well, no, I just saw Alana shaking her head. So our next panelist is Candace Myers. Candace Myers is a family law and divorce partner at Bierman LLP. She's been practicing family law exclusively for 20 years. Candace is originally from Youngstown, Ohio, raised by parents and grandparents who had strong ties within the Jewish community. She received her bachelor's degree at Indiana University studying political science and business, and earned her law degree at the University of Ohio. In 2017, Candace received her 40-hour mediation certificate from Northwestern University. In 2019, she moved her practice to Bierman, honing her creativity, pragmatism, and relationship building skills, and shifting her practice to both litigation and alternative dispute resolution in complex, high conflict, and amicable cases. Candace believes in the delicate balance of knowing and understanding the law and considering her clients' emotional needs, those of the children, and the best interests of the family financially. Candace is grateful for the services of the Beis Din of the Chicago Rabbinical Council, understanding the unique needs of divorcing families in our Jewish community. Candace, thank you.
Thank you so much. And I just at the onset want to say I feel very privileged and was very grateful when I received the call from Judge Goldberg to speak today. And I appreciate you reaching out and letting me be a member of this panel. My beginning years of practice, I would say some of my most memorable times were practicing in front of Judge Jerry Bender. And I remember his wit and his practicality, and I learned how to be a litigator in front of him. So this is really, really special. And I see a lot of my family law colleagues here on this Zoom. So I hope that I don't stand corrected in anything that I say, but I did focus this outline on sort of a mix of folks who are practitioners and folks who in the community want to learn more about mediation and how it applies to divorce. So I apologize if it's at all elementary to my colleagues out there. First of all, the requirements of divorce in Illinois requires you to go through certain processes, and there are different process options. And as practitioners, I believe we have the ethical obligation to explain to potential clients what those process options are. It isn't just filing a petition for dissolution, going to court, getting served with a summons. There are other options. So, of course, there's the traditional mode where if you have a dispute, you go to court, you file motions, motion practice, litigation, where a court decides. A court decides what the parenting time is. A court decides whether you have to pay spousal support, maintenance. A court decides temporary issues. And a court decides where parents are going to live and how parents are going to practice their holidays. And within the traditional model, if there are like-minded attorneys, I do find that you can come to a boardroom table and sit down and talk about what those practical resolution is. But again, it is determinative of who the attorneys are and what their practice philosophy is. So outside of litigation is mediation and collaborative divorce. So mediation, which is the key to what we're talking about today, is when a third party neutral facilitates the agreements of the parties. And you can mediate parenting issues and you can mediate financial issues. I'm going to get into like the key tenets of mediation in a moment. But another process option is collaborative divorce. And collaborative divorce is a holistic process where it's interest-based negotiation versus positional-based negotiation. Generally, there is a mental health provider who is the coach, the team leader. You have attorneys for both the spouses. And if there's complex financials, there's a financial neutral. And in the collaborative process, it's a special process where you sign a contract, all the participants sign a contract saying, we will not go litigate. We will go to court on the final day. We will do the final prove up, entry of judgment. But if we threaten litigation, if anyone wants to go to litigation, the process starts over. You have to get new attorneys and you can't use any of those prior discussions. It requires transparency and it requires open access to all the financials and the children. Again, it's interest-based negotiation, not positional-based negotiation, which is what we as attorneys learn in law school. We learn in law school kind of like split the baby. If you think that the house is worth $1 million and the other spouse thinks the house is worth $500,000, let's split it in half and say it's $750,000. With collaborative and with mediation, you can be a little more creative. You can say, okay, well, my big concern is refinancing because the interest rates have gone up and I want to stay here for the children until they graduate from high school. And so you can be a little more creative with kind of the credits that go back and forth and how long a party is required to do the refinance or the assumption of the mortgage. So those are the process options. And I always, when potential clients come into my office, I really don't even talk to them about what their assets are or what's going on with the kids. I give them process options because I believe that this is their life and they should be able to choose their road. Of course, sometimes they come when the process has already started for them. But I believe that if parties are even educated at the onset a little bit about alternative dispute resolution, it can make a huge difference in a case. And I can say that, at the end of the day, parenting allocation judgment will look the same if you go in on an order of protection at the onset or you start and sit down with a private mediator at the onset. Generally speaking, unless there's some, outside serious restrictions and serious endangerment, you're going to walk out with the same piece of paper. But how much is this one going to cost versus this one going to cost? How are you going to raise grandchildren together? How are you going to go to the wedding of your children together when you have gone to court and aired out all of the privacy, all of the dirty laundry. And so I think just having that conversation at the onset with my clients does make for, at least I can sleep at night and say, okay, these people are in conflict now, but hopefully they can live their life beyond me as their divorce lawyer. Um, so what's required? We have a judgment for dissolution of marriage, but how do we get there? Well, you can get there by agreement, which is it's a contract. You come to an agreement on all the terms. You come to an agreement on maintenance and how you're going to divide the house and the retirement assets and the liquid assets and the stock accounts and the restricted stock units, etc. And you come to an agreement on the parenting allocation. And I'm going to talk about what those requirements are in a second. But coming to an agreement, and it is a contract, and it is enforceable, and it can't be unconscionable. Another way that you get there is by trial. So if two parties cannot come to an agreement, then the courts are there to rule. And you put on a trial and you call your first witness. And the judges who sometimes practiced in family law before and sometimes did not listen to the credibility of the witnesses, the lawyering, whether it's good or bad, of the attorneys, and they come to a ruling. And the third way to get divorced in Illinois is by default. So if, I will send a letter to a spouse saying, I've been retained by your spouse to represent them. They want to do this amicably. Please have an attorney reach out. And then an attorney doesn't reach out. And so then I send another letter. And then we file a petition for dissolution of marriage. And sometimes the spouse just doesn't want to participate. And there are certain rules once they've been formally served in a time frame that you can ask for a default. And if a spouse is missing, like I have had cases where the parties have been married for over 20 years, one of the spouses has been in a different state, living totally separate life for decades. They don't know where they are. You make a good attempt to find them, and then a court will grant a divorce by default. What you need as part of a final divorce is a financial agreement, which is the marital settlement agreement, or a financial judgment. And if there's children, you need a parenting allocation judgment. So mediation and divorce, why I think it's so important. And obviously the Illinois Supreme Court finds it important, and our local circuit courts have certain rules as well. Key tenets are confidentiality, privacy, creativity, transparency, and voluntary participation. So as far as confidentiality, I think, I went into this a little bit earlier, but I don't believe families should be discussing in a public forum their mental health challenges or their substance abuse challenges or their parenting missteps. And where I find it actually really offensive is when attorneys run to court and they counsel their client and they put in a public record. They file an allegations listing one by one of what the parent did wrong and what's wrong with the parent and the mental health issues with the parent. And when you're in mediation, it's confidential. You cannot use the correspondence. You cannot use the settlement discussions in court. And I think if we fast forward to where this family is in 5 or 10 years, I think you have to think about with your clients, or if you're a potential party to a case, where do you want to be in 5 years with the person who you trusted the most and you loved very much? And so confidentiality and privacy is key. As far as creativity, Judges are required to follow the letter of the law. We have a statute, we have case law, and the judges cannot really go outside of those four corners. But in mediation, we really can be more creative. We really can think about, okay, so a judge is going to allocate Rosh Hashanah, which they don't even that often because we live in a secular Cook County, Lake County world. But I'm going to use that as an example. They're going to just allocate it even odd. But what you can do in mediation is say, okay, well, my family's from Ohio, and I always travel to Ohio for this, part of time. And the school's off for the 10 days. And so I want all Rosh Hashanah and you can have all Passover, or you can be more creative, but the courts are not equipped to be that creative. Transparency. I think a lot of folks are concerned that I don't know what my spouse has been spending. I don't know what the finances are. I haven't been part of the finances. If I don't go to court, then I'll never know. Well, it doesn't matter in mediation, in court, you still have the opportunity to do discovery. And you should know ultimately what you're contracting for. Am I waiving the rights to his or her retirement account without knowing the value of that retirement account? Am I waiving that school pension without knowing what the, valuation on that pension is? And so I have a lot of clients who come to me and they say, I've been in mediation, I've been with the based in, but I know that he or she has been spending on the credit cards and I don't understand. We got a loan and, but it was for our mortgage or our HELOC and it's spent down. What happened? So you still have the availability to request those documents. And I specifically had a hearing in front of the based-in where the documents were required. And it wasn't contentious. It was, hey, my client would like to know what the financial documents say. How long will it take for you to turn them over? And then my client can make a decision. Bobby, how am I on time? I'm okay.
You can go for another 5-10 minutes.
Okay, good. Okay, so mediation is for settlement purposes only. Can't go to court and say, well, in mediation, she agreed to waive her interest in the retirement account. Why won't she now? Or in mediation, he agreed to write a check for $150,000, but he's not willing to now. And you can't use that. There's Supreme Court rule that states that any settlement negotiations, any settlement documents can't be used for purpose of evidence in court. Mediation can be attorney assisted or self-represented. So I don't think there's a right or wrong way. I think sometimes depending on who the attorneys are and the balance or imbalance of power or the imbalance of knowledge, if you have two parties who are knowledgeable of the finances and are relatively equal partners in terms of parenting, they can go to mediation and represent themselves. I have plenty of clients who do that, but they also have my number and we talk before and we talk afterwards. So they go in completely ready and prepared. When there's an imbalance of knowledge or an imbalance of power, where one spouse is a partner at Jenner and the other spouse is a stay-at-home parent, I wouldn't send in my stay-at-home parent spouse to mediate with the partner at Jenner when he or she may not have that sophistication of understanding the capital contributions to the partnership account and may not understand the intricacies of the deferred compensation plan and things of that nature. And there's also this personality imbalance where one parent was really tasked with raising the kids and the other parent was tasked with being the breadwinner. On the flip, if I have a client who feels marginalized from parenting and really has been wedged out, I don't know that I would send that parent in to advocate for themselves, to have that full and rich relationship with the kids and have a good parenting agreement. What does concern me sometimes is when you have two attorneys, and sometimes attorneys, as we know, do have large egos or a little alpha personality. And so we sit there with our clients and they hired us. And, we want to advocate and show how much we care because we have to earn that trust and that fee. And that sometimes doesn't lend to a good mediated agreement or a good process. And I think that falls on the mediator to say, okay, let's shuttle, which is be in separate rooms, or I'm going to have separate one-on-one meetings, or hey, attorneys, your client's fine, step back. And I think a good mediator should kind of step up and say that. And I think a good attorney should have that self-awareness too, but there are all types. Mediators can be retired judges, attorneys who specifically are just mediators, or attorneys who advocate for clients and also do mediation. So taking the 40-hour mediation course and kind of having their toe in both places. I explain that to people and I say, well, I mediate, but I could not be your mediator because I've already given you confidential advice. And so now I'm not neutral. And of course, the based in has mediation, which is why we're here today. So what I want to say is truly, when Rabbi Reese said that they're available at all times, I can attest to that. They understand the nuances of the community and they really are available at all times and jump in substantively. I was surprised when I first started working with Based In how pragmatic they are and how in line really they are with the circuit court and the kind of the secular mediation mode and where we are in 2024 with parenting, with dividing finances, with discovery. And I want to say one thing. I want to thank Rabbi Abramson, who was working with the Based in a couple of cases that I had, along with Ms. Lipman and Rabbi Reese. He brainstorming and understanding and that practical decision making, and they truly are listening and want to help the families get from point A to point B. I have in the materials a variety of statutes. So there's a requirement in Illinois section 602.10, which is a parenting plan. And there's Illinois Supreme Court Rule 905, which governs mediation. And I think the big takeaways are courts generally require, not generally, I'm going to say a little more than generally, they do require before you get into a dispute about decision making and removal, which is removing a child from our Illinois jurisdiction, that you have to go to mediation first, that you have to sit down with the other parent and attempt to talk about it. And there's rules governing what can be done in mediation in our state. Supreme Court Rule 922 does have time limitations on any custody dispute. So from the time someone files and is served, there's 18 months for a court to make a decision. The two attorneys can go in on written motion for good cause shown to extend the 18 months. And I will say practically, some judges are very rigid in the 18 months. and maybe don't know that nuance of Supreme Court Rule 922 and are hard no, it is month 17, we will decide this. But then there's other judges who maybe get the nuances, maybe practiced in family law, understand that you can't come to an agreement when there's really challenging mental health issues, substance abuse issues with parents with lots of children. Maybe the children have special needs. You can't do that sometimes in 18 months. Sometimes going to a rehabilitation facility is 4 or 5 months. So now how are we going to finish this in 18 months? And it kind of goes back to, I don't file a lot of my cases until the end. So we don't have that tolling, but that's kind of a nuanced way that I practice. Local rule in Cook County 13.4E, I'm using as a specific. I practice in Lake, I do a little DuPage and in McHenry, but Cook County, Judge Dickler, who's now retired and she's mediating, and Judge Scanicchio have really leaned into the rules for mediation from a practical standpoint. I practiced with Judge Scanicchio, early on in my career. She did a lot of GAL work, and they're really being thoughtful about mediation being a way to solve problems for these families. With parenting, it's required. With financial, it's discretionary. But I think using mediation for financials, again, you can exercise so much creativity and discretion. Does someone who is, let's say, a member of the Pritzker family, someone who in this community, like in the city, is a big public figure. Does that person want their personal life in a public record? No. They want to sit at a boardroom table with a neutral facilitating an agreement and not putting out there that the balance sheet has $942 million and this is where all the allocations are. So the intersection between Jewish law and secular divorce law, all of it. And I think anecdotally, Cook County judges will allocate what they perceive as major holidays. They're not going to mandate or have a conversation about Sukkot. They're not. I
Thank you,
think,
Candace.
yeah. One last thing is enforceability that Rabbi Reese talked about is so long as it's not unconscionable, it will be stamped and signed by a judge. So you have to deal with things that within the law, so it's not unconscionable. Thank you.
Thank you very much, Candace. It was a very thorough presentation on divorce and civil law, and we're looking forward to hearing the intersection now between Rabbi Reese's presentation and yours with our next panelist, Alana Lipman, who works at the Chicago Rabbinical Council based in as the Director of Divorce Mediation Services. Alana works with Jewish couples through mediation arbitration to reach marital settlements. She holds a bachelor's degree from New York University, a JD from Cardozo Law School of Yeshiva University, and she completed the divorce mediation training course at Northwestern University. And she wanted me to let everybody know that she lives in West Rogers Park, has a husband and 3 kids. Alana, welcome.
That's the most important. Okay, thank you to Judge Goldberg and Declog for having me. I'm honored to be on this panel with Rabbi Reese and Miss Myers. So I'm going to just share my screen. Sorry, give me one moment. Okay. like was previously said, I'm going to speak about the intersection of mediation and our what we provide at the CRC, Jewish Divorce Mediation. So what does divorce mediation look like at the CRC? So just right off the bat, I want to explain that divorce mediation is not reconciliation services, not shalom bias assistance. Unfortunately, by the time many of the couples get to me personally, the marriage is broken down and they're ready to mediate their divorce. So it is, like was previously said, it's a very similar process to, any type of secular mediation, just with an overall halachic and Jewish law lens. I always say to our clients coming in, the biggest benefit of working with the CRC is the guidance of the Rabbanim at the CRC. Like was also previously said, we're very, very involved. We really work as a team effort, and I really appreciate, the Rabbanim that are involved and the guidance that they give our clients along the way. Most of our clients that come live their lives day to day with a halachic lens, and this experience should be no different for them. So we hope to provide that for them. We will always respect and incorporate Illinois law or any state that the divorce is being filed in, and obviously as well as Jewish law, while working through all the issues. So like was previously touched on by both Rabbi Reese and Ms. Myers, we go through all the issues in a divorce. Basically, how our process works is the parties will come to me first and for an intake, and generally we will do these intakes separately. In a lot of our cases, there's a dynamic where there's a lot of tension in the beginning. Obviously, it's a very vulnerable situation, and the parties don't feel comfortable expressing in front of each other what the situation currently is. So, of course, if they prefer, I'll do the intake together, but most of the time I do it separately. So both of their voices can be heard and both of their perspectives can be respected. At this initial intake, after I hear the details of their perspective, I'll discuss our mediation arbitration agreement, which Rabbi Reese touched upon before, which basically says they are coming to the Beis Din to mediate their entire divorce. And if mediation breaks down in part or in whole, the arbitration clause in our agreement is triggered, and they'll come to the Beis Din for an arbitration. I'll get into the details of the arbitration later on. I'll through our process, Candace touched on it also before, we can either do shuttle mediation or facilitative type of mediation. Facilitative type of mediation is really the ideal. It's the most productive and efficient to sit in the room with both clients and hash it out and really help them cultivate communication skills together and help them work through the issues together with me there facilitating the conversation, being the neutral, making sure tensions are, everything stays a bit calmer, than it has been. But this is not always easy for our clients. There's, like Candace said before, there could be different positions, there could be different knowledge levels of both parties. A lot of the times, one of the parties, it was much more involved in the finances and has a much more thorough knowledge of the finances. And the other party potentially has a much more, day-to-day involvement with the children. So they both kind of have experience more or less in one area, and it may be hard for the clients to sit together and feel confident enough to hash things out and feel like they have a voice and feel like they can really advocate for themselves. I try to do my best to keep things calm and keep them, an equal playing field, but it's not always the case. So in a lot of our cases, I'll do something called shuttle mediation, which is I'll go back and forth and have conversations with one client, go back to the other client and discuss and hopefully bring proposals and counter proposals and hopefully get to a mutual consensus as efficiently as possible. In the beginning of mediation, we'll try to settle as many issues temporarily as possible. A lot of the times we'll have to figure out a temporary parenting schedule. So because, your day-to-day life doesn't stop just because you're unfortunately going through a divorce. So if you have children, you need to figure out where the children will be staying primarily, who will have overnights when and where, who will have visitation at this time and that time, what everybody's comfortable with. So we'll have to jump into those issues right away, usually. Obviously, specific to the Basin and working with the CRC is the understanding of the Jewish holiday schedule and the schedule with Jewish private schools and things like that. So if we are starting our mediation in August and we know the Chagim, the holidays are coming up in September or October, we'll jump into those issues right away, and we'll try to set up a family, to feel comfortable going to the Chagim, that it's not so too confusing for the children. It's not, it's their new normal. So we help them navigate that as quickly as possible. We'll also discuss their temporary finances as they're, figuring out the new dynamic with two separate homes instead of one. Like I said before, we speak about parenting time, which is the kids' schedules and things like that, and legal decision making, which touches on, if both parents are going to be involved with the decisions of where the children are going to go to school, how they're going to be raised religiously, where their doctors are going to be, all decisions like that. That is in many cases that is usually split 50-50 where both parties are involved with those decision makings. But obviously it's a case by case basis. We will discuss the property and assets of a case, mainly or sometimes most importantly, the marital home, which could be a very big issue in a case. We'll discuss child support. Like Rabbi Reese discussed earlier, the maintenance or ketubah money that a party is entitled to. Like he explained earlier, you're not really, you shouldn't be double dipping into both. So it's an either or type of situation. We discuss insurance and medical expenses and tax issues and debts and extracurriculars and tuition, which obviously is very important, could be very important in the Jewish community because many of the children are in private school, and this is not included under child support amounts. So obviously, take into account the specifics of a certain case and a certain community, but we have to figure out who is going to pay for what percentage of the private school. And then we also discuss get timing, when the parties are ready to participate in their get ceremony, and discuss everything that goes along with that. So Jewish mediation specifically, the CRC offers cultural sensitivity to both Jewish life and American legal considerations. So like was said many times, we try to really have our hand on the pulse of what's going on in this case, how it relates to the community, how they feel specifically in their lives. Everyone at the CRC has a lot of experience, of course, working in the community, forging relationships in the community. And I really try to understand our clients as much as possible on a personal level. And I hope, and I think it's helpful for them that I can relate to them on many issues and understand them, on a deeper level while they're going through this very, very vulnerable time in their life. We have a commitment to seeing the process through. And I have many clients that we work with post-divorce as well. These issues, unfortunately, sometimes don't end, when you stamp when you file the MSA in court. There's many situations where the parties still need help post-divorce. And of course, our our goal is to, like I said before, help cultivate communication between the parties as much as possible, because they're going to have to co-parent with each other for the rest of their lives if there's children involved. But we are always there to help facilitate a conversation. And we try to pride ourselves on transparent expectations throughout the settlement process. We do our best to, set deadlines and commitments. We try to have both parties commit to a certain level of expectations throughout the entire process. Obviously, the mediation is much less costly than legal representation, which everyone is very well aware of here. And we try to, be as responsive and efficient as possible. Like I said, and willing to engage for as long as necessary throughout the process. Like Rabbi Reese touched upon before, we discussed the get process. Ideally, the get is done, if as long as all those factors like Rabbi Reese spoke about are there. It should be done, towards the beginning of the process. I try to maintain as much as possible that the get conversation should not be used as leverage. It should not be included in any of the negotiations. And I try to, confirm that and maintain that as much as possible between the parties. And the capacity for arbitration is something that the CRC is able to facilitate should mediation not yield an agreement. So like I said before, if mediation breaks down in part or in whole, the arbitration clause of our agreement is then triggered. So we could just mediate certain issues in the case, and hopefully we resolve as much as possible and we come to mutual consensus between the parties as much as possible. And there could be certain issues that we take out and we go to arbitration, or an entire case can be moved to arbitration. So arbitration when necessary. So like I said previously, the parties are agreeing at the outset that, we may have to move to arbitration if mediation breaks down. The way an arbitration works at the Basin is the parties can request either one Dayan judge to be their sole arbiter, or a three judges panel. So it depends on the details of the case. It depends on the party's preferences. Each party can bring in representation to argue their case, and they are welcome to bring in any evidence that substantiates their claims, and bring in any type of witnesses that helps bolster their case. And we try to facilitate that as much as possible. After the arbitration has ended, the Dayanim, the judges, will have time to deliberate and discuss privately, and then a decision by the Beit Din will be rendered as soon as possible. We try as efficiently as possible. And like was said multiple times, the Beit Din has final jurisdiction over financial matters, but does not over parenting issues. But the decision of the arbitration decision holds a lot of weight in court. So as long as everything was done in a proper manner. So divorce mediation, the CRC is a unique offering. The CRC is one of the few Batei Din nationally, and I think internationally, that offers this process of mediation, arbitration, as well as facilitating a get. Even though I am an attorney and Rabbi Reese is an attorney as well, we are not acting as legal representation for the parties. We are neutrals, and nothing we discuss in mediation should be used in the legal process. And like Candace said, it's completely confidential. Our fees are $200 an hour and $100 for a half hour. We obviously work on a sliding scale for many of our clients. We'll never turn someone away if they cannot afford our services. We will work with them as much as possible, so they're able to be a part of this process. And our main goal is to help the community, is to help people in the community. So that is our main objective here. So in terms of, I'm so grateful to be speaking to this large group of attorneys and other people in the community, because a big part of my job is to cultivate relationships with divorce attorneys and with other professionals in the community that aid and guide our clients, because I really do believe that working together is much stronger and much more effective than working as separate pieces. I think that we can be a productive team together. I think that the clients in this vulnerable situation, they need to feel like they have a trusted team behind them, as well as a neutral mediator that's cultivating and facilitating the communication with their soon-to-be ex-spouse. I worked over the past year and a half. I've worked with many attorneys, Ms. Myers included, and I really believe that the more that communication is open, the more that we both see that our goals are aligned and we want the best outcome for the client, and we want to make it as the least contentious as possible, and the overall perspective of what's in the best interest of the children, what's in the best interest of the family for the long run. I love the way Ms. Myers said it, that you're going to be at your grandchildren's weddings together in years to come, and you should have that perspective the entire time. It's especially in the Jewish community, the family aspect is foundational, and it's very important for everyone to have that goal in mind. So I think the more we can work together, the better. And the attorneys, the divorce attorneys, can help me see the perspective of the client together. This way I can, come back and forth and discuss with both parties. And it makes for just a more trusting environment for both parties, and they should both feel heard and respected throughout the process. So this is just some discussion points that we've experienced in the Basin. Some challenges that we faced. So one is both sides feeling comfortable to commit to and understanding our process and trusting our process. Obviously, I think when most people hear divorce, their first inclination is getting a lawyer, going to court. I think that's basically the more known process, and it might be a little bit more foreign to people to discuss mediating, and especially discussing mediating with the Basin in a divorce case. So also another big part of my job is to explain our process thoroughly and help them feel like they have a say in what's going on in our process, that it could be much more beneficial to them, instead of going in front of a judge and a judge deciding their entire life, that they together get to make those decisions respectfully and thoroughly. They get to discuss what's best for their children in the long run. And also just explaining the part of the Basin overall's involvement in their case, and how and when the Rabbanim get involved, and the aspect of halacha, and Rabbi Reese and the other Rabbanim do a great job of that, of how it all intersects. So it's a very important part of my job to educate and to be very thorough. So the question also of involving attorneys or not, and what to extent the attorneys are involved. So like I said previously, I find it very beneficial when the attorneys are involved. Obviously, like Candace was alluding to, as long as we all have the same goals, and we're all working, we're all trying to work efficiently together. But I working with attorneys is very expensive, so I try to keep it as limited as possible. I always say to the clients, it's very important to have an attorney in place, but not at play. So because yes, I am an attorney and Rabbi Reese is an attorney, but we cannot give legal advice. So if they have any sort of question that falls under that category, they need some advisement, they need an attorney there to speak to. So we'll do our best, to help them as much as possible and guide them in the best ways possible. But sometimes there's no choice but to consult with your attorney. So it's always, like I said, we should always have an attorney in place in case. And at the end of the day, we will come up with a memorandum of understanding, a mutual consensus of the issues between the parties, but the attorneys need to turn that into a MSA and file it in court. So that's also another big reason why you need an attorney in place. So a big issue, obviously, is the challenges in the get and Jewish divorce process, like Rabbi spoke about before. Like I said, it comes up in the beginning of a process, and I do my best to, facilitate that conversation as easily as possible. And I really do feel that the Beit Din works as a team in that way and helps everyone be able to feel as safe and comfortable as possible on both sides. Safe and comfortable as possible, that their needs are being met and that we are respecting both parties, and that the interests of both parties are really important to everyone involved. And we are trying to move forward and do the right thing in the right time. The decision about whether or not to divorce is also in the process. So like I said earlier, when the parties come to me, normally they're past that point, but the decision to actually divorce starts if I get a sense that a party is questioning, I will kind of pass the baton to Rabbi Reese or the other Rabbanim to kind of get involved and kind of guide the couple if they are really ready to take this next step of pursuing the get process and pursuing mediation, because we are not in the business of divorce. We're not encouraging, divorce when it's possible that someone could work through issues together. Obviously, there are certain cases you have to be very careful, and we will incorporate outside experts to help decide if a case should move forward or not. But we're not in the business of just someone comes, that's it, divorce, it's end. So that's a important conversation to have. And a big issue is an analysis of whether mediation is or will be productive, or should we go straight to arbitration? So there's many cases, I think Candace was speaking about it before, that sometimes mediation is not going to work. Mediation has to be, both parties have to want to mediate. Both parties want to have to be involved in this conversation and want and have to participate willingly to make proposals and counter proposals and work together to come to a mutual consensus. It is not beneficial to anybody involved to drag out mediation when neither party is, or one party is not willing to negotiate or be flexible on any level. So many times I'll sometimes get a sense in the beginning, but we'll always try to, mediate as much as we can to save, time and money for everyone involved. But we'll get a sense that it really, one party or both parties are really not looking to work together. So we'll just move straight to arbitration. And there's no issue with that. It's beneficial in many ways. It could be more efficient. It could be just make sense for a certain case. And I think that's it. I think we wanted to discuss some questions and maybe specifics about cases, but that's all I have on my presentation.
Thank you so very, very much.
Thank you, Alana, for your very well organized and very informative presentation. You can stop sharing your PowerPoint. Thank you. And now it's my pleasure to once again call upon Judge Mitchell Goldberg so that he can moderate the question and answer segment of this morning's program. I know I saw at least one question that was posed.
Right. Before we get into that, I just also want to share with everybody that in the chat, Rabbi Mostovsky has also posted a link to the CRC Based in Services. So if you want to click on that link, you'll be guided to additional list of menu of the services offered by the CRC.
There is one other thing I want to mention just to make sure, because we've got about 7 minutes left on our allocated time, and I'm going to ask any of the attorneys who want the CLE credit, please make sure that you fill out the survey form that'll show on the screen before we conclude so that you'll be able to get that credit. Take it away, Mitch.
All right. Before we open the session to questions from the audience, I do want to thank our esteemed panel for their time and thoughtfulness in their presentations in identifying approaches for some of the issues that face cases involving Jewish litigants and families, and the benefits of CRC mediation. The issues arising in divorce cases can be complex and challenging. They touch on every possible legal issue in law and chancery. Apart from the legal complexities, domestic relations disputes are often highly emotionally charged because they address the challenging issues which are part of people's very identity and how they define their own value and success, whether it be as spouses, parents, homeowners, or business owners. I highly regard, personally as a judge, the very many professional practitioners like Candace who appear before me and advocate for their clients or serve as GALs. And I've seen several of them on the Zoom. Mm-hmm. Good practitioners are always looking for as many tools as they can find for their toolboxes to achieve positive outcomes for their clients and long-term stability for families. They're also in the business of looking for cost-efficient methods for their clients. And as can be seen from today's esteemed panelists, the very sophisticated, pragmatic, and frankly empathetic and extremely accessible offices of the CRC, including the CRC mediation services, can offer a significant resource to attorneys for these efforts. So now let's take the questions from the audience. The first one is from Don Engels, and he's asking a question regarding alimony. And I guess this would be for any member of the panel. The issue is, how does maintenance, I guess, how are those issues treated under Jewish law, and how do they arise in disputes?
Okay, I guess I'll start. The maintenance issues are treated under Jewish law in a manner which is very similar to that of secular law from a pragmatic and practical perspective, because Jewish law recognizes that you should implement whatever is the implied condition or explicit condition or the custom and dealing of the parties. So if the parties went into their marriage with sort of an understanding that their finances would be governed according to local custom, and local custom is that assets are split, or that when there would be a consideration of what belongs to whom, you would take into account the factors of equitable distribution. So then that would be respected by Jewish law as well. In a vacuum, if you didn't have any particular custom and you were just relying upon classic principles of Jewish law, so then there would be a system where when a couple got married, a wife would bring in a dowry into the marriage, where she would bring in certain assets that she would get back at the conclusion of the marriage, and whatever earnings came in during the course of the marriage would depend upon whether there was sort of a deal that the husband supports his wife in return for which she gives him her earnings, or whether she chooses to keep her earnings on her own. Nowadays, when most people work quote unquote outside of the home, and wife's earnings are not confined to her sewing skills inside of her living room, it's generally assumed that each party has a right to their earnings if they commingle their assets in joint bank accounts that are considered to be shared assets. So then those would typically be split 50-50, and the same would be attributable to the debts incurred by the parties together over the course of their marriage as well.
Did anybody of the other panelists want to chime in on that? All right. The next question was asked and also kind of answered by Candace in the chat. This is by Mark Weiner. When the field of divorce mediation was first developing years ago, the mediators going through training were both attorneys and therapists. Is this still the case today?
Yeah, from my experience, when I did the 40-hour mediation course, it was all those three professionals, therapists, and there were actually some former parties, litigants, who felt like they wanted to be part of this divorce process further, so they took the 40-hour mediation course. But there isn't a limitation from my understanding. I mean, there might be a limitation on becoming a certified mediator under the Cook County rules, what professions you can be. But I would have to look at the local rule on that.
Retired Judge Michael Jordan asks a very interesting question regarding conflicts. What do you do when a party is a member of your or Rabbi Reese's synagogue, or is a neighbor or classmate, or was previously?
Look, the Chicago Jewish community is more of a close-knit community than when I lived in New York, and there were fewer cases in which I was familiar with the litigants who came in front of me. There were some cases where I was familiar. Sometimes I have a second cousin come for a get at the Bet Din, for example. So here I draw a distinction, really it's a Jewish law distinction between disclosure and disqualification. That if you're familiar with the party, so then it's always necessary that you provide a disclosure. This person is a neighbor. This person is somebody who is a congregant at my congregation. And I would say that I feel comfortable sitting on the case. So if I didn't feel comfortable, I would just recuse myself automatically. And then it's up to the parties to determine whether they're comfortable with whatever associations I might have or any of the other judges might have in the case. Generally speaking, they come to the Bet Din with an expectation that we're familiar with the parties to some degree, or the party's brother-in-law, father-in-law, or cousin, or whatever the case may be. Sometimes we don't know or have any connection to the parties, but often we do, and then it's just a disclosure issue. If we really feel a closeness, we are very socially close to the parties, or that we have some sort of an interest in the subject matter of the proceeding. So then that would be a disqualification. It wouldn't just be a disclosure issue. Then we would just remove and recuse ourselves from the case.
And I just want to say, obviously, like Rabbi said, that Chicago is a smaller community. I haven't had any issue with that so far with any of my clients. If I've seen them in the community, I'll kind of feed off of them, and I'll follow their lead if they want to say hi to me or not. But for most of the time, the clients do, and we won't make a big deal if I'm seeing them in the supermarket and things like that. But it's so far hasn't been an issue for me.
And one of the things that the Chicago community is also blessed with is a really sizable number of great rabbis. And the CRC based in does have a fairly large bench of their dayanim. So to the extent that there's a conflict with one of them, there are other dayanim that can step in and participate.
We're so careful not to get too friendly with anybody. It's a judge's life.
We have a question from Pamela Kuzinar. It's a good question. In mediation training, we learn how to access for domestic abuse to determine whether medication is appropriate, and if so, what protective mechanisms need to be in place, and what is the process at the CRC in, I guess, cases where there is domestic abuse.
You can take. Okay.
No, mediation. She meant mediation, not medication.
I'll just say, and then Maurice, you could add if anything necessary. If there's any hint of anything abuse type of related with the spouses, with the kids, with anything like that, we'll always incorporate outside experts. We'll always get as much help as possible to navigate the complexities of the case. And then Rabbi Reese can talk about if maybe the case is not appropriate for the Beis Din. So if it's beyond our purview. So we always are aware of our abilities and also limitations, I think. And we always want to bring as many outside experts as possible into the case.
An important question, obviously, to the extent that you need to have outside experts when it comes to concerns regarding the suitability of parents to serve in custodial capacity. So just like a court will bring in expert testimony, whether a person has overcome certain addictions or whether certain inappropriate behavior from 30 years ago is going to be a factor in the future and things like that, we'll bring in that expert testimony as well. But sometimes there are things that really are in a criminal category where you have to just draw the limits of your own jurisdiction. And the Bet Din understands that when it comes to certain types of concerns and dangers that are out there, it's more appropriate to say this is beyond our purview. We can handle civil cases. We can handle the types of matrimonial cases that would normally be dealt with in family court. But if there's a need for an order of protection, there's a need to go to the criminal authorities for something. So then we authorize and we direct the parties to do so. And we say we can't take responsibility for that. We need to know, we need to be aware of the limits of our own jurisdiction.
And one thing that also I think should be mentioned as a reminder of part of Ilana's presentation is that the CRC does have the ability to do proceedings remotely. So Zoom is a way to make sure that people feel safe. And the technique of using the shuttle mediation, I think shuttling is also a very good technique for purposes of making sure that the participants in the mediation process feel safe at all steps of the mediation.
And I can say, Pam, for as far as impediments to mediation and whether it could or can be successful, I found that the Based-In is just as receptive to the concerns as and handles it just like private mediators or like Cook County mediators. I find it consistent across the board.
All right.
Any other questions? I'm going to respect everybody's time. It's 11:35. We ran 5 minutes over. If there were a pile of questions, I'd ask people if they wanted to stick around for another 10 minutes and get another quarter of an hour of CLE, but I'm not going to do that unless I hear something real fast. Uh, in that case, I want to thank all of our participants on the panel, Rabbi Yonah Rees, Candace Meyer, Ilana Lippman, and my vice president from the Decalogue Foundation, Judge Mitchell Goldberg, who moderated this question and answer session. I also want to thank our executive director, Aviva Pat, for all of her assistance in this morning's presentation. Aviva, would you please post the survey so people can fill it out and get the CLE credits? And while you're doing that, I'm just going to pose one other question. One of my professors from the University of Chicago, Linda Ginzel, specialized in negotiations. And I'm not going to get into the BATNA technique, but one of the things when you have all kinds of different issues, and it's just not just monetary, like you do in a divorce, is you figure out what each side puts as a relative importance to each one of the components, because you might be able then to give everybody greater utility out of the settlement than just trying to split every single category down the middle. Is that the technique employed in the CRC mediation?
Yes, for sure. It's definitely obviously, of course, if the clients want to split everything 50-50, that's great. But of course, we value what's most important to people throughout the process, and we discuss the details and the nuances of things, and not just say everything is split down the middle. We try to do our best to do that.
Thank you. That's great to know. And I want to
Yeah.
remind everybody here that I don't think you can find mediation services that are priced at $200 per hour split between the parties in any other venue other than the CRC, which is essentially using all of its resources to help provide a service to the community at much lower cost and with great skill. So I want to thank the CRC for providing that. We're getting our responses back on the survey. Uh, Everybody's doing pretty well.
And I just want to caution the co-hosts, the speakers, and the moderator not to even look at touch the survey, because that stops it, and then no one else can complete it.
I'm not touching it, just looking.
Just letting everyone know. If that's it, I will stop the recording if we're done. Bobby?
That's it. We're done. And I want to thank everybody once again. It was a great presentation, very informative. And I hope that people who participated will be able to pass the word so that the CRC will be able to increase the level of service they provide to the Jewish community, the broadest Jewish community. I will say just from personal experience, one of my study group partners in law school unfortunately went through a horrible divorce. She got married with a Reform rabbi, and the CRC was very helpful to her because she knew that when she went to a different Based-In, and she had a recalcitrant husband who told her that if she wanted to she'd have to sign over the house that she bought when they were getting married. And the CRC worked it out so she got a get, and they were able to do financial settlement without extortion. And lo and behold, she got remarried, and it was a good thing that she got the get. So, regardless of affiliation, the CRC provides services to all of the members of the Jewish community.
And a thing that wasn't actually discussed, but is also important for practitioners to remember, is that the CRC mediation facilities are open for pre-litigation mediation as well. So even before the divorce has been filed, if everybody knows this is going forward, before the clock starts running, as it were, on the time requirements with respect to litigation matters, the CRC mediation services could be utilized.
Thank you.